Here at Scott Legal, we know the ins and outs of immigration. We are here to help you navigate the oftentimes complex road in achieving your immigration goals. We have new immigration videos every week. If you are new to the channel, please hit the subscribe button and bell. You can also sign up for one of our webinars, or get a free immigration guide, by clicking the link below. Many clients ask, can I stay in the US on a visitor status, and continue working remotely for my foreign company, while being paid in my foreign account? This video has your answer. In the aftermath of COVID-19, more and more professionals have embraced working remotely, and a rising number of professionals are wondering what are the legal consequences of setting up a remote working arrangement in a foreign country, while continuing to be paid from their employers from their home countries. Since this is technically not working for a US employer, would someone on a B1, B2 or ESTA be able to do this? This is a tricky situation, and lawyers are divided on this issue. Immigration law makes it clear that a B1 or B2 visitor to the US cannot engage in any form of work in the United States. Work is usually defined as the performance of skilled or unskilled labor. However, it is an open question on whether, or when, working remotely for a foreign employer, while staying temporarily in the United States on a B1 or B2 visa, counts as work. As a general matter, business visitors are admitted under the B1 classification to participate in seminars or conferences, negotiate contracts, consult with business associates, or undertake independent research. For example, during their trips, B1 business visitors may engage in activities that are incidental to work that will principally be performed outside the United States, provided that the principal place of business and accrual of profits remain outside the United States. However, if your activity in the United States is closer to performance of skilled or unskilled labor, even if done remotely, especially for a prolonged period of time, it may be difficult to argue that your activities in the United States are incidental to your work performed in your home country. Visitors for pleasure, such as tourists, are admitted under the B2 classification, and may not engage in any employment. It is generally understood employment in this section refers to employment by US entities, but the regulations do not specify this. Does performing services remotely for your foreign employer count as employment? This provision is likely not meant to prohibit tourists staying in Florida for a week, for example, from spending a few hours in their hotels, during their vacation, to reply to work emails and answer calls. However, the implications could be different if an employee of a foreign firm sets up a home office in a room that they rented in New York City, spends 8 hours every workday logging in and performing all of their duties from their computer remotely, and continues to do so for 6 months, even if the foreign firm pays the employee at their foreign bank account. There could also be tax consequences. In sum, given this ambiguity in what is considered employment, it could be a safer choice to avoid engaging in productive activity in the US which is close to performing skilled or unskilled labor, regardless of the entity that is employing you, especially if you are doing so for a prolonged period of time. If you are interested in finding out more about this issue, please do not hesitate to reach out to one of our lawyers for a consultation. To learn more, take a look at our resources in the description box below. You can also sign up for a free visa guide, any of our upcoming webinars, and Facebook groups. You can also schedule a consultation for a date and time that is best for you. We are here to help. You can contact us by calling 212-223-2964 or by sending us an email. We look forward to hearing from you.